Hi, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about investment and distribution trustees and why you might need both of them. When creating a trust, it is common to name yourself as the initial trustee who is responsible for all aspects of administering the trust. However, when considering who will take over when you can no longer act, either due to an illness or a death, it is sometimes helpful to divide the responsibilities between two or more trustees. So for example, you may decide to have one trustee who manages the accounts and property held by the trust, and another trustee who makes decisions about distributions to the trust beneficiaries. Now, there's some important reasons why you may want your trust document to bifurcate trustees' duties in this way. So one of the benefits is that you have specialized knowledge or aptitudes from these trustees. Now, trustees have a variety of duties and responsibilities in administering a trust, and it is sometimes beneficial to divide them up between more than one trustee based upon the expertise or skills needed to perform a particular aspect of the trust administration. So for example, if your sister-in-law is knowledgeable about investments and experienced in making financial decisions, but is not as skilled as handling potentially difficult interpersonal interactions, it may be beneficial to name her as your investment trustee, which is a trustee whose sole duty is to make discretionary decisions about the investment of funds held by the trust. Now, some trusts call for distributions to be made to beneficiaries at the trustee's discretion, rather than mandatory distributions of a certain amount or percentage at certain times. For trusts that provide for discretionary distributions, it may be helpful for another trusted person capable of making impartial decisions, skilled at communicating with others, and familiar with the beneficiaries of the trust and their needs to be named as the distribution trustee, which is a trustee responsible for making decisions about whether and when to accumulate or distribute the income or principal of the trust. Now, the division of responsibilities is particularly helpful if there are any difficult relationships or potential conflicts between beneficiaries or between one of the trustees and a beneficiary. So for example, if your second wife is one of the trustees of the trust, but the beneficiaries of the trust are your children from your first marriage, naming an unrelated third party as a distribution trustee may avoid some hard feelings or the perception of unfairness related to distributions. Although it may be more expensive to have two or more trustees instead of a single trustee, the additional expense may be worthwhile to maintain family harmony and avoid damaging relationships. Another benefit of having these two different trustees is that you might gain additional asset protection for your beneficiaries. Now, most creditors may not reach a beneficiary's interest in a trust if the trustee is not required to make distributions. Some creditors may be limited in how much they can reach if distributions are based on an ascertainable standard, such as for health, education, maintenance, and support of the beneficiary. Now, depending on state law, this may be true even if the beneficiary is also the sole trustee. However, the general rule is that the less control a beneficiary has over the trust accounts and property, the more protection is provided against creditors' claims. Even if the beneficiary of the trust is also the investment trustee, greater asset protection may be available if a separate distribution trustee is appointed who is empowered to make distributions to the beneficiary in their sole discretion. In some jurisdictions, the trust could also provide that the beneficiary could resign as a trustee and appoint another independent trustee to take their place. This might further enhance the level of asset protection if the beneficiary is concerned that they may become more vulnerable to creditors' claims in the future. Now, I just want you to keep in mind that this asset protection is typically not available for certain creditor claims, such as child support or alimony or tax debts. The list of those exception creditors does vary by state, so you do want to discuss that with your estate planning attorney. It can also be helpful to have two different trustees to minimize taxes. Now, when a trustee has total discretion to make distributions from the trust to themselves or others, The value of the trust accounts and property may be included in the trustee's estate for estate tax purposes, or the trustee may be taxed on the trust income under the IRS. Depending on the type of trust and the goals it is designed to achieve, an independent trustee could be appointed to minimize either estate or income taxes. So, for example, to avoid having the property held by the trust included in their estate for estate tax purposes, a trustee who is also a beneficiary may be permitted by the terms of the trust to select an independent distribution trustee. As long as that distribution trustee is actually independent and not a related party or a person subordinate to the beneficiary as defined by the IRS. In this situation, the investment trustee, who is also a beneficiary, will not have direct control over the amount or timing of the distributions, but may still retain significant control over who serves as that independent co-trustee. In addition to choosing the independent distribution trustee, the trust document may provide that the beneficiary can replace the independent trustee at any time and for any reason. So, for example, if your trust is what we call a non-grantor trust, meaning that the trust is just a separate entity for tax purposes that pays taxes on trust income at the trust level, it is important for someone other than the grantor, the person who created the trust, or any party who is related or subordinate to them, to be the investment trustee. And that's because the power to determine trust investments may be considered to be the power to control the beneficial enjoyment of the trust assets, which would mean that the grantor, rather than the trust, must pay taxes on the trust income. If you'd like to find out more about whether you should appoint separate investment and distribution trustees, then give us a call if you live in Massachusetts or New Hampshire, or call a qualified estate planning attorney in the state in which you reside to set up an appointment for you and your family. Although having more than one trustee will make the trust more complex and additional fees may be required for the services provided by those trustees, you may decide that the benefits far outweigh any additional costs. So I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families.